Welcome to Prime Debate. The executive and the judiciary are once again at loggerheads over the issue of the appointment of judges to the Supreme Court and the High Courts. The centre has favoured a review of the Collegium system, which gives the judiciary an upper hand in the appointment of judges. In Prime Debate, we discuss the larger picture of what system could work on the appointment of judges without infringing on the rights of the executive and the judiciary. Prior to 1993, appointments of the Supreme Court and the High Court judges were made after a consultation process in which both the judiciary and the executive had a say. Subsequent to the 1993 judgment in the Supreme Court Advocates on Record case, the judiciary, however, has been enjoying absolute power in the appointment of judges through the Collegium system headed by the Chief Justice of India.
In recent times, appointment of judges has drawn flag from various quarters, particularly after the aborted elevation of erstwhile Karnataka High Court's Chief Justice P.D. Dinakaran to the Supreme Court. The Prime Minister had asked the Collegium to reconsider the names forwarded by it for appointment of certain judges to the Supreme Court and the High Court. But the Prime Minister's request was not considered by the judiciary, which stuck to its decision. The government now has favoured the review of the Collegium system. The constitutional provision under Article 124(2) and Article 217(1) is that a judge is appointed by the President after consultation with the CJI. The government is not bound by the CJI's recommendation. However, after the 1993 judgment in the Supreme Court Advocates on Record case, the judiciary has been enjoying absolute power in the appointment of judges through the Collegium system headed by the Chief Justice of India. Now, the Supreme Court has referred a set of 10 vital questions for consideration by a larger bench on the constitutional validity of the Collegium system. The questions framed include whether there exists any Collegium system of appointment in the Constitution, whether the Constitution can be amended by a judicial verdict, whether there was a constitutional scheme that the Supreme Court and High Court judges can be appointed by mutual discussion and consensus between the judiciary and the executive, whether consultation means concurrence, whether there was any convention that the President is bound by the advice of the CJI, whether the opinion of CJI has any primacy in the appointment, and whether the earlier decisions could be overruled by a larger bench. The government's open advocacy for a change in the judges' appointment system has come at a time when the judiciary has been actively questioning it on issues of corruption and transparency in executive decision-making process.
To discuss this issue, we have in our studios Justice K.S. Garewal, former judge of the Punjab and Haryana High Court, Dr. P.S. Jaswal, Vice Chancellor, Rajiv Gandhi National University of Law, Patiala, and Justice M.S. Gill, a former judge of the Punjab and Haryana High Court. Welcome to the discussion, gentlemen. Justice Garewal, I'll start with you. Are you in agreement with the Union government's plea to the Supreme Court to review the Collegium system?
Yes, I would say the Collegium system needs a relook, and we need to revisit the process of selection of judges, but it has to be done in such a way that we do not weaken the independence of the judiciary, which is of paramount concern to all of us. If you look back in the time of Indira Gandhi, she was talking about committed judiciary, and she wanted to have the Chief Justice of her choice, and she superseded 3 judges to make Justice Ray the Chief Justice, and the 3 judges resigned. Now, that was a big setback to the principle of independence of judiciary and the principle of seniority. So I think as an aftermath of that, probably the Supreme Court judges thought of strengthening their own say in the selection process. But now that was also about 18, 19 years ago. So perhaps this is the right time to rethink and to come out. So this is the right time to
rethink. But Justice Garewal, some people are questioning the government's intent. They feel that the government's move comes at a time when the judiciary itself is questioning the government on a lot of issues, including corruption.
I don't think that's a valid objection. I don't think so, because after all, judges, the executive and the legislature, they're all 3 wings of the government. There is separation of powers, but the state has 3 wings, and they have to work in harmony with each other. And there's no harm if there's a serious discussion on the appointment process. But it should not be reduced to a frivolous kind of, finger pointing at the judges, because that would weaken the institution of the judiciary. We should strengthen the system.
So it should be done very, very carefully and after a great debate.
It has to be done in a statesman-like manner, definitely, yes.
Dr. Jaswal, what is your view? Should the collegium system be reviewed?
Of course, because the past experience has shown that the collegium system has not worked to the satisfaction of all. And I think there is a need to review the collegium system.
Some people feel that, there are a lot of inconsistencies in the 93 judgment vis-a-vis the constitutional provisions. What is your view?
If we read Article 124 Clause 2, then the President is to appoint the judges of the High Court and the Supreme Court in consultation with the Chief Justice of India, who may consult such other judges of the Supreme Court and the High Court. So the discretion was left in the Constitution to the Chief Justice of India to consult any number of judges or any of the judges of the Supreme Court or of the High Court, concerned High Court, so that he could arrive at the just decision. But the 1993 judgment and then subsequently 1998 judgment, which brought this concept of collegium into operation, this consultation process was left to the senior most judges. So in a way, whatever the Supreme Court said in 93 and 98 judgment, that is not provided in Article 124.
So in some ways it is contrary to the provisions of the Constitution. This is what the amicus curiae A.K. Ganguly has said. He feels that the 93 judgment as is being interpreted is contrary to the constitutional foundation of the separation of powers and the system of the checks and balances.
No, but the system of checks and balances is still there to some extent, but once we gave the total primacy to the Chief Justice opinion.
No, but if you give total primacy, then where is the system of checks and balances?
So that is what I am saying, there the checks and balances system has weakened. And of course, the Supreme Court can interpret the constitutional provision the way it likes. And in this case, they have interpreted that yes, the Supreme Court should have a primacy, or the Chief Justice should have a primacy.
Justice Gill, you have had a long experience. You are a part of the collegium in the Punjab and Haryana High Court. What is your experience?
You know, taking that view that the collegium system has failed is going too far. If you take it from a different angle, it's the judges where lawyers are appearing before them every day. It is they who understand as to what is the competence of this lawyer. Every case for a lawyer is a test case. His competence, his honesty, his way of working in the court, his conduct in the court, only the judges can understand. If you take it that way, the Chief Minister is going to understand that what is his performance in the courts. That is going too far. The Chief Minister will not recommend a person on the basis of the merit which a judge can. If the judges are really honest to recommend the names, especially judges of the collegium. But now the Chief Justices are going beyond the collegium also. Justice Garewal can bear me out for this, that they are taking recommendations from down till about the 8th or 9th or 10th judges or some other judges in writing, not disclosing it to the members, not disclosing to us. The Chief Justice does consult the judges. So taking a complete view that yes, it has failed, I am not ready to take that. The judges, I feel, are the best persons to, maybe all right, you've got the Chief Minister, you've got the Law Minister, you've got the Prime Minister, you've got to take them into confidence to a certain extent, but the upper hand must be with the judiciary.
But how come the Law Commission in its report in 2008 favored restoration of the pre-93 position, and permit me to say that even the Union Law Minister, Virappa Moily, has said the same thing? Well, why is there such a clamor to go back to the pre-93 system?
You know, the executive is coming for the judiciary. Everybody is coming for the judiciary, and not only the executive. If we say just the executive is coming, no, everybody, the press, everybody is coming for the judiciary. Meaning, there's a reason in it. Judges want to be independent. They want to give independent judgments not for themselves, let's say for the public, for the individual. Well, then you're hitting at the system. You're going for the system. Somebody in the some individual in the system you're hitting, who may be a very powerful person. Well, when he gets his time, he wants to get back. Now the executive wants to get back to the judiciary. Take these powers away.
But Justice Gill, that could be one interpretation. The other interpretation could be that there is so much faith in the judiciary that people want absolute independence of the judiciary.
Yes, of course, the judiciary has got to be independent. You can't have a Chief Minister or any person in the ministry or anybody for that matter trying to tinker with the independence of
But was that, Justice Garewal, was that happening? The political appointees, the chief ministers, were they interfering in the appointment of judges before the 93 system came into being?
You see, they would make recommendations and the Chief Justice would look at them and by and large agree. But I'm told that out of all the recommendations made in the earlier system, probably there were 7 to which the Chief Justice did not agree, but still they were.
This is in the Punjab and Haryana High Court?
No, nationally.
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 Otherwise, they more or less agreed with whatever was being
there. It used to be working in a sort of a give and take way, but I don't have any direct experience of that. But I still feel that
when you say give and take, that looks like a very dangerous statement.
No, not give and take in a statesman-like way, not the kind of give and take.
What do you mean consultation?
The consultation, and they would consider everyone, and
not a quid pro quo kind of a situation.
No, not in that sense.
Because consultation has got to be effective consultation. It's not the Chief Minister goes or the Chief Justice. Effective. A number of meetings here. This is the plus. This is the minus.
But Justice Gill, now isn't it surprising that even Justice J.S. Verma, the former Chief Justice of India, who perhaps headed this bench which went in for the Collegium system, even he is in favor of a review and going back to the pre-93 system?
Well then, I mean, that's his view, and he may be seeing some flaws it now, and now he's seeing those flaws. He may not be seeing those flaws then. But again, I want to repeat one thing. What I said before is, there's got to be a balance, but the upper hand is got to be with the judiciary. Yes, you can't have the Chief Minister as a post office, you can't have the Law Minister as a post office, you can't have the Prime Minister's office as the post office. If they object to someone, yes, the Collegium and the Chief Justice must take it into consideration as to what are these objections coming.
Actually,
yes, Dr. Jaswal.
Actually, what Jassab is saying, the same thing was there in the mind of, I believe, in Justice Verma, and he went on record to say to the press that probably his judgment was misunderstood. He wanted to maintain that independence of judiciary, and at the same time, the Chief Justice of India should not enjoy the total freedom. That was probably the consultation process with the other senior most judges was introduced in that judgment of 1992. But ultimately, the focal point is that yes, we have to maintain the judicial independence.
Dr. Jaswal, before you go into the break, I want to check with you. Now we have 2 judgments. One is of 93 and the other is of 98. These are perhaps 7 or 9
7 judges and 9 judges bench.
Yes. So what happens now if it is reconsidered? Will there have to be a larger bench, a special bench?
Yes. Now the Chief Justice of India has to constitute a larger bench, that is now 11 judges bench, which is a special bench which can be constituted to reconsider the 9 judges bench judgment of 1998.
Justice Garewal, you were saying something?
Yes, I would like to say that it's not been pointed out in the press and other places. One of the flaws of the Collegium system is that they are not quick enough to fill in the vacancies. And so many vacancies are continuing for a long time.
And also what is happening is that once there is a replacement of a Chief Justice, the next Chief Justice very often wants to revise the list.
He has to revise, or he has to take time to have a relook at the whole thing. So that is one thing against the Collegium system. It's not working quick enough. And I don't know why it is like that.
So the Collegium system is not working quick enough.
So I'll also say that some of the session judges who are ready to be promoted to the High Court are their elevation is held back because some lawyers have to come up. Before that, they can't find enough lawyers to fill